I'm Matt Richardson. I'm a partner at Rudnick. I run their cybersecurity and data privacy practice. As you can tell, I am not American, but I do work here in America, and I have a huge advantage over every speaker that comes up after me, which is that this accent raises my IQ by about 10 points. Now, it's just an illusion. Don't be fooled. So I'm going to talk to you about, just to set the scene a little bit, about AI and the way we're moving. And to do that, I thought that I would trust in AI. And so as we speak, I'm going to ask ChatGPT to generate my speech for me. So ChatGPT, write me a speech about business and legal risks in AI. Go. Shit. As a large language model, I cannot assess business or legal risks. Please try later. Damn. Okay. Shit. Okay. But I did actually, that was not true. Because that is the first lesson in AI, which is do not rely on AI. It cannot help you in mission critical situations. All of you out there, you will be inventors, you'll be innovators, entrepreneurs, thinking of new ways to use AI in your systems, in your companies, in your projects. And by all means, please do that. And I get phone calls day in, day out from entrepreneurs trying to find some new way to use AI in some way that nobody has ever thought of before, and I've certainly never even thought of before. But you will come up against guardrails. And if you rely on AI solely, you will find yourself, certainly in the future, but today at least, you will find yourself in a very sticky wicket because AI cannot be trusted for a number of reasons. Just across the river in New York, an attorney is currently being disciplined by the state bar for putting a pleading in front of the court that an AI generated for him. And that AI produced a number of legal citations which looked legitimate, which contained a real judge's name, a really properly formatted citation, and contained all kinds of judicial language and proved his point completely. He put the pleading in front of the court. He was very happy with himself, only to find out that the AI had completely invented those cases. Not only did they not happen, the judge did not exist, and the law as it stood was completely against his position. But the AI suffered from a hallucination or potentially even a delusion. Now the difference is that a hallucination, when you hallucinate, you see something completely wild and you sort of recognize that you're not seeing something that is reality. But in a delusion, you don't recognize that what you're seeing is not reality. And AIs are unfortunately, presently, susceptible to those problems. And if you are not monitoring that and checking the reality yourself, you are subject to a problem. Now that is the best case scenario for what happens. It turns out that for a long time, AI has been quite dangerous. I mean, we're seeing the retail use of AI now with ChatGPT, with large language models, and soon, and I'll talk about this towards the end, large action models. But AI itself has been going for as long as computers have been going, really. Machine learning, machine vision, machine listening, all of these things have been going for quite a long time. And in fact, the first AI to kill a person happened long ago, long before I was even born. 1979, Robert Williams, working in the Ford factory in Michigan, was accidentally mistaken for a door of a car by an AI and was mounted to a car. Now that is fatal for humans, it turns out, and since that point, AI has still been doing damage, whether or not they were driving cars automatically into rivers or whether they were accidentally producing the wrong information in a medical document. AI is still very dangerous. And as a result of that, and the retail exposure that is now occurring in AI, we are seeing, as they are wont to do, regulators and legislators all over the world stick their oar in to the regulation of AI. And that, I am afraid, is often fatal for any business enterprise, because regulation and legislation usually starts in the European Union, and I'm afraid the European Union's approach is to find regulation that is, if they were trying to undermine business, they couldn't do a better job. And that is unfortunately where the regulation is going to start. And the European AI Act, which is currently in front of the Commission and being debated at the moment, which will regulate AI, will almost regulate it out of existence. And it's based upon these 3 or 4 threat areas. The first is cybersecurity and data privacy, which is the bread and butter of my practice at Brown Rudnick. And it turns out that a lot of these large language models, a lot of the way in which AI is being used is not entirely secure. And the manner in which they are processing data to produce these large language models is not consistent with the principles of the European data handling scheme. That is to say that there is no transparency. Even the people running LLMs don't really know how LLMs operate. Once they've got the data inside them, they sort of take on a life of their own. And that is against the first principle of data protection in the European Union. So the European AI Act will regulate data protection in large language models and large action models beyond a level where it is useful for businesses. Now, that's not the end of the world, because mercifully none of you are in the European Union, but if you intend to push products in the European Union, you will be subject to those acts. The second and slightly more insidious problem is that of bias and discrimination. It turns out that, much like people, large language models develop a bigotry. An unfounded bias occurs within these models, and once it appears, it cascades throughout the model and is very difficult to undo. And so any of you producing models that require, let's say, hiring, or any models that revolve around interacting with people, must be very wary to design those models and monitor those models for bias and discrimination, which is unnaturally occurring within these models. Again, it's a huge problem which will, I'm afraid, lead to litigation at some stage in the future. I should also say that I don't have any answers for any of these questions beyond being able to give you a risk assessment of what's going on in the world. I can tell you that these problems exist, and I can tell you that they're likely to cause difficulty for businesses in the future. But I don't know, I'm afraid, what the legislatures are going to do, what the regulators are going to do, and what the courts are going to do when these issues inevitably come in front of them. We've seen already that intellectual property within AI is a big problem, because occasionally AIs generate material which is already somebody else's intellectual property, or they generate material that you yourself would like to claim as your intellectual property. Well, the US Copyright Office has already said that they will not accept or copyright material that has been generated by an artificial intelligence. And that means that material you are generating, which you potentially would like to use as your own, cannot lawfully be protected from use by your competitors. Likewise, if the AI, the flip side of the coin, if the AI steals some intellectual property from somewhere, which of course they have to, because they're taking tokens and language from other websites. In fact, Google Bard takes language from our website. We have tokens in Google Bard. Nobody else does, but there's very little we can do about it because we cannot see that that material is being produced elsewhere. Now, in cases where the material produced elsewhere is easily identifiable as copyrighted material, that will lead to litigation and certainly lead to a loss by the person who has produced the copyrighted material. So these are things you have to watch out for. But finally, and much more worryingly for all of you, is I'm afraid that liability in these circumstances is not certain. Is it the person operating the large language model that is responsible? Is it the person promoting it? Is it the person putting the prompt in? Is it the person using that material is responsible? Is there liability shared amongst all four of them? I'm afraid that because these things happen so very quickly and the developments have happened, come into the public consciousness in such a way that the world hasn't yet really adjusted itself to understand what's going on. And as regulators and legislators stick their oar in and do so in their usual ham-fisted and anti-business way, I'm afraid that the best thing you can do is come and find me and my colleagues and at least ask us for some comfort or at least some point to the business risks associated with it. And that is the best possible advice I can give you in relation to the way in which AI is working. On the flip side, how do you create value, protect value in AI contracts? Well, to answer that question, I've got to tell you a story about the real Slim Shady. In 1998, when I was at high school, Slim Shady, Eminem, was like the biggest rap star in the world, and he had entered into a recording contract, and the contract was for 5 years, renewable to 10, and gave him a royalty of 20% on all CDs and records sold, and 50% on all other music sold. And in 1998, the only way you could sell other music was through movies or through advertisements, and that gave him a 50% royalty. Well, that's great. Fast forward to 2003, when ringtones were outselling CDs nearly 2 to 1, and Eminem sold more ringtones than anybody else. And his record company wanted to stop him from taking that 50% royalty, but of course they couldn't. And it got worse because in 2003, iTunes was launched, and CDs basically fell off a cliff. And his record label sued him, and in fact, he won that lawsuit and claimed the 50% royalty on everything that had been sold as iTunes and as ringtones. And what that tells us is that we cannot predict where the market is going to be in 5 years' time. In fact, probably today, you think about how ChatGPT launched and ChatGPT took 1 million users in 5 days. Well, nobody could have predicted that. And so to protect your IP, to protect your value when dealing with these contracts, it is important to avoid making decisions relating to the technology itself, but instead to try and contract relating to value and value alone, and identify the value proposition within what you are selling and make sure that you protect that value proposition. And as my time has run out, I can tell you that the best way to do that is to come and find the lawyers at Brown Rudnick and tell them that you have stuff to protect, and we will look after you. Thank you very much for having me at Propelify. What a wonderful day, and please have a great time. Thank you very much.